Okay, so we will now move to the next panel, which is devoted to the respect of procedural guarantees in the process of dispute resolution on social media platforms. So we will have this discussion with Pietro Ortolani, Emmanuel Vargas, and Naomi Appelman. So it is with great pleasure that I introduce our next speaker, Pietro Ortolani, who is a professor of digital conflict resolution at Radboud University in the Netherlands. Pietro Ortolani has made significant contributions to the field of online dispute resolution, ODR, showcasing this deep interest in exploring the intersection of conflict resolution and technology. His research also delves into how courts and arbitral organizations are being transformed by technological developments. We are fortunate to have him share his insights with us today on the respect of due process in online content moderation. Pietro, you have the floor. Thank you.
Thank you so much, Florence, for the invitation. It's a pleasure and an honor to be with all of you here today. And I will try to kickstart the discussion for this second panel by tackling the challenges that we are all facing when it comes to implementing due process within the field of social media and in general platform content moderation. Let me start with 4 questions. Number 1, should this person be allowed a social media account? Number 2, on a platform, a trader is advertising their products by showing a countdown. There's only 2 minutes, 53 seconds for a consumer to decide whether to buy the product. That is not true. It's a so-called dark pattern. It is essentially a psychological trick to induce in the users a sense of urgency. You need to make a decision right now. Example number 3. How and to what extent should an e-commerce platform tackle counterfeits that appear on their pages? Example number 4. Should people on social media platforms be allowed to show depictions of blackface? I don't want to put a photo of blackface on the slide, so instead here's a photo of my hometown, Montecatini Terme. It's very beautiful, you should all visit it. Now, jokes aside, these 4 issues have very little to do with each other in substance. However, when you only have a hammer, you tend to see every problem as a nail. And in today's world, where everything is content, every conflict, or a wide range of conflicts that are not really comparable in substance, tends to manifest itself as a content moderation issue. So the hammer we have today to tackle this widely diverse set of challenges and problems is this: complaining about it with the platform, asking the platform to do something about it, asking the platform to moderate content. So the underlying conflicts are extremely diverse in nature, but somehow content moderation has emerged over the last 10 years, I would say, as a possible, pretty accessible way for users to complain about all of these issues. And of course, that means also giving platforms responsibility to make some kind of decision on all of these issues. Now, how are these decisions made? In a number of different ways, as we have already learned earlier in the first panel. First of all, with AI, and I would say generally with algorithms and automatic decision making. Now, when I think about algorithms in this field of content moderation, it's not always machine learning, it's not always a very sophisticated form of automation. Sometimes it's a mere pattern matching. For example, an algorithm recognizes a certain word or a certain picture that has already been uploaded on the platform, right? And that is enough to trigger some kind of reaction on the part of the platform. That does not require, at the very first stage, any human intervention. But of course, that's not all. Next to that, you have human moderators. And these are people that are tasked with the difficult task of reviewing a big volume of content and applying pretty detailed case-by-case guidelines on what should be or should not be allowed on the platform. So, do you see this? Leave it on. Do you see that? Take it off. They are expected to make decisions very, very quickly. And sometimes it's within the staff of a platform, but often it's also outsourced to external service providers. But then next to it, content moderation has been evolving, we have learned already, and there's also different experiences that enrich this type of decision-making, and I think one of the most interesting ones is the oversight board that we already talked about, because that is an example of platforms, in the case of Facebook, Instagram, and Threads, that actually embrace the adjudicative nature of content moderation. So basically, rather than sweeping the problem under the carpet as mere housekeeping, as mere internal governance of the platform, it's an acknowledgement that this is important, that's also very difficult, that it involves human rights, that people really care about it, and they should be given a sufficient degree of due process. And that means in difficult and significant cases that have the potential of informing the future policy of the meta platforms, referring it to this authoritative body that has, as we have learned, significant expertise in different fields, freedom of expression, journalism, human rights law, and putting them all together to try to develop a consistent approach and a reliable approach that will inform the future content moderation of the platform. It is also human intervention, but it's very different from a moderator that in 10 seconds needs to decide whether something should be taken off or not. So there's a lot of flavors, but can we get some kind of empirical insight in what prevails? And yes and no, but thanks to the DSA, the Digital Services Act, with respect to the European Union, we have some limited degree of scrutinability of what happens within content moderation. First of all, we already talked about, the current scale is quite impressive. So this is a screenshot from some months ago. I think in the meantime, it's grown because there's more VLOPs. Initially, there were just 16. Now I think we are at 23, if I'm not mistaken. And over 20 days, these 16 platforms make 251 million something statements of reason. And those are statements that the platforms under the regulation must make whenever they decide to moderate content. For example, to remove or to demonetize a certain post, or to suspend or terminate an account, you name it, any kind of content moderation measure. Next to it, of course, there's the millions of cases where the platform reviews a complaint and refuses to moderate it. Because, for example, it's spam. It's what we have already learned in the first panel. Mainly, somebody being upset about a fight they had online and clicking on the button, which is, because it's so easy to do, it's also prone to be abused. So the current scale of content moderation is clearly incomparable with other types of decision-making that we have been talking about, like judicial decision-making, right? That's a first interesting data point I think we should keep in mind. Then, another thing that the DSA allows us to look into is actually how much automation do platforms use, first of all, in detecting illegal content, for example, and second of all, in moderating that illegal content. So detection is something that can occur because somebody complained about it, but it can also occur, of course, and it very often occurs, because the platforms themselves have tools that detect the upload of certain types of content that might be illegal or incompatible with the terms and conditions. And in fact, for many types of illegal content or incompatible content, the typical policy of the platform is to actually even prevent the upload of the content. So if you try to upload, a Marvel movie on YouTube, there's actually a filter at that stage, already at the upload stage, and it's entirely automatic. But what the DSA has shown us, and it's quite interesting, is that not all platforms do the same thing. So the platforms need to disclose in how many cases they use entirely automatic decision-making in the detection and in the decision on whether to moderate content or not. And we see that there are some platforms that have a lot of automation in the detection. That, of course, is next to the notice and action mechanism, to the human complaint. But then a relatively low degree of fully automatic decision making. So some degree of intervention of a human moderator occurs before a decision is made. And that is, according to the data on the DSA transparency portal, the case, for example, for the meta platforms. But there are also other platforms that in practice do everything automatically, or almost everything automatically, and that's the case for the App Store, for example. There's also other platforms that use very little automation, in fact. For example, on X, you have not so much automation either in the detection and in the decision making. So it's interesting to see when you actually open this box, this general box of content moderation, it's not all one thing. It's a lot of different practices by different companies for different reasons and different business models probably behind them. So having this as a descriptive picture, the question becomes, how do you ensure in this brave new world of content moderation some degree of due process? And the idea I would like to focus on today is this idea of digital due process. It's something I've been working on over the years, and it starts from a very basic observation. That is to say, technology is making its way into public dispute resolution. We have more and more technology in court, for example, but we also have a lot of decision-making, significant decision-making in the private sector. That doesn't mean only arbitration, mediation, what we typically study in law school when we talk about out-of-court dispute settlement, but also platforms. Right? So technology somehow is creating this new field of digital adjudication that goes across traditional disciplinary boundaries. And the question is, how do we ensure that due process is respected in the entire field? Because otherwise the risk is that we create these beautiful guarantees, but they only apply to the very rare cases where a judge will be hearing a case. And then we have this million of other cases where no judge will hear the case. So my main proposal here is that we need somehow to together discuss how to update this idea of due process and fundamental procedural rights. Because it is, in a way, impossible to deny the need to apply these standards also to the private sector. We already talked about indirect horizontal effect, or maybe just horizontal effect of human rights law. But at the same time, it is impossible to simply take the old guarantees that, as we have learned, have been developed with respect to the state and with respect to, when it comes to procedural rights, national courts, and simply transpose them to this new machine and expect a company that is a different animal, of course, to uphold the same type of standards while at the same time processing 250 million decisions over 20 days. So we need to somehow update due process and decide what is very important to keep and what should be somehow marginalized to allow moderation at scale, which in itself is necessary unless you want a platform to become a cesspool of disinformation, hate speech, pornography, and so on. So somehow bridging the public-private divide, and I would say also leveraging the technology itself. So due process in this context should not only mean basically looking at what's happening in content moderation and complaining about it, saying, oh, you should have more transparency, you should have more accountability, more independence and impartiality, and so on. That is important. I don't want to marginalize this type of discourse. But at the same time, I think it also means getting our hands dirty with the technology itself. To a certain extent, to a large extent, I think the problem should be fixed at the level of building the technology. When building an infrastructure for content moderation, you are essentially writing procedural law through code. And that code should be written and should be developed having in mind the importance of these fundamental procedural rights. A typical example is indeed case selection. Case selection is, in the oversight board example, the equivalent of what common law courts, for example, the US Supreme Court, do with the process of certiorari, right? So if that is a fundamental procedural step, the algorithms developed to scan through these 1,000 complaints a day and find the right one, find the interesting one, should be developed having in mind this idea of digital due process. But how to do it? Well, I have some open questions for you, because, of course, I'm not here to give you a final answer, but hopefully I can trigger a debate, and let's think together about this topic. My first proposal and my first open question for all of you is whether we need a new human-machine synergy. What do I mean? Well, as I mentioned, the sheer volume of content moderation prevents us from thinking that humans, by themselves, can take all of these decisions without any type of automation. That is practically impossible within the time that a platform has to make these decisions. And I would say also undesirable, not only because it would be financially unsustainable, but also because it has an invisible cost, which is a human cost, which people don't talk about enough. To have a human moderator review content means, in practice, that you will have somebody, for example, that for the entire working day looks at a screen and assesses live streams of teenagers that might be about to commit self-harm. That is grueling work. Training an algorithm to do the same work means having annotation of previous content to determine whether it is, for example, a depiction of self-harm. That also comes at a significant human cost. This is work that is often undertaken by workers, not at the platform itself, but actually outsourced to places where workforce is cheaper. And the human cost of this type of work should not be underestimated. So there's economic reasons, practical reasons, governance reasons, but also I would say workers' rights reason to have this synergy, to have a role for automatic decision-making in this field. And I would say the need that we are facing is to go beyond this dichotomy. So instead of saying, should this be done by a human, or should this be done by the Stanley Kubrick evil computer, we should realistically think, how can I use certain forms of our automation within a process that also has a human in the loop, and that ensures meaningful human control? Again, I don't have the answer, but I think the need to go beyond the binary choice is the starting point here. A second important and difficult question is how you ensure this new idea of due process at scale, while, ensuring that this huge volume of conflicts, complaints, is swiftly dealt with. Now, from online dispute resolution, which is a field that has now a history of 30 years, we have learned that to manage high-volume, low-value disputes, it is often useful to adopt an escalation logic. That is to say, if you can resolve certain types of complaints, hopefully many complaints, at a very early stage, even with purely automatic decision-making, that's great, because you do some kind of triage and you sift through the mass and you allow the difficult cases to emerge and to escalate to the level that maybe an oversight board will decide about them. And you can also leverage, to a certain extent, the repetitiveness of these cases. People will complain about the same stuff. And if you have already taken a decision, not only it's efficient to adopt the same decision in similar cases, but it's also, of course, important in terms of isonomy, in terms of consistency of decision-making. But there's also other ideas that are newer and I think fascinating to discuss. The first one is indeed this idea of building some kind of transnational body of precedent. So basically, a body of previous decisions that will guide platforms in moderating content, irrespective of where the platform provides its services. Of course, while taking care of the factual specificity of the case, which also means cultural context. That is what, indeed, the Oversight Board aims to do by applying and clarifying the community standards in all countries where Meta offers their platforms. But there's, as I mentioned in my question earlier, a significant obstacle, that is to say, will national lawmakers at some point make this impossible? because they will not allow platforms to moderate content that is lawful but awful, content that is not illegal but is incompatible with the terms of service. Now, if a platform becomes an essential utility, then that is a problem. And in practice, from what we have learned with the DSA Transparency Portal, terms of service complaints basically eat up everything else. Right? So illegal content is theoretically a very important category, but in practice, most of the moderation happens on the basis of contract. So if you cannot do that anymore, you're throwing away the baby with the bathwater. But there's another idea, because all of these ideas, of course, have been somehow entertained by lawmakers and leveraged by the European lawmaker in particular. And this other idea is, in fact, to open up the dispute resolution market for this type of disputes. So basically to say, eventually, there should be a chance for the users, as we have already learned, to bring this type of dispute outside of the platform. And the DSA notoriously does that by trying to create an open market for certified out-of-court dispute settlement bodies. So this logic of proceduralization and escalation is quite visible in the DSA. I made this little scheme for my students to show them how different provisions of the DSA relate to each other and how you start from a very simple notice and action mechanism, and then the platform provides reasons if they moderate the content, and then you have the right to internal complaint handling that's not entirely automatic but is still within the platform, and then you will have this new possibility of out-of-court dispute settlement, and eventually you have the possibility to complain about DSA violations with the coordinator of the member state where you are established, and you can go to court, as you could before, right? So this logic of escalation, with some cases eventually going to court, but not all of them. So it's a huge procedural machinery, right? There's a lot of new opportunities for dispute resolution. But the question is, will people actually use that? And sometimes when the question comes up, the mind goes to this common, Silicon Valley mantra, if you build it, they will come, which actually dates back to an old Kevin Costner movie from the 80s. But the idea is, it's what my students call manifesting. So it's kind of magical thinking. You create the machinery. If it's out there, people will use it. And in practice, I think, yeah, sure, it might happen, but it might also not happen. If you look at previous attempts of the European Commission, for example, some of them have been dramatically unsuccessful. For example, in commercial consumer dispute resolution, the European Commission created an ODR portal, an online dispute resolution portal, and it's used so little that, in fact, the Commission proposed to just discontinue it. So it's not true that if you build it, they will come. And when I am faced with these intractable theoretical problems, my philosophical northern star that always guides my thinking is always the same: pizza. I love pizza, but without some kind of yeast, the dough will not grow. So this is a nice dough, I think, but it needs a yeast to grow, to actually work, to go from flour and water to an actual tasty pizza. And I think the yeast is you. It is lawyers. It is a difficult but important question. What do you want to see in this? What do you want to see in, for example, out-of-court dispute settlement? Is it procedural law? Is it something that we will teach in law school? Is it something that we see as a new field of legal practice and a new way of protecting rights? Or is this just a nice tea for a conference that we will forget tomorrow when we start teaching civil procedure again? It's up to us not to marginalize these instruments, and I think it's up to us to create a new generation of lawyers that will think, this is how I protect people. Not necessarily always by going to court, but by leveraging the entire arsenal, if you will, that the DSA has created. Only time will tell, but please help me be the yeast. Thank you very much.
Well, thank you very much, Pietro, for this very interesting presentation of the balance between, the keeping of due process and, on the other side, having quick and cheap resolution of the problems online. Well, so we keep in mind that there is, of course, a cost. having a human moderator. And it's not only an economic cost, of course, there are other costs linked to that. And now we are going to hear the second speaker that I'd like to welcome to this panel. This is Emmanuel Vargas, who is a PhD candidate at Örebro University in Sweden. I hope that I said it correctly, but I'm not sure. I don't speak Swedish. And he's writing a thesis on the human rights implications of automated content moderation by social media platforms. He is also particularly interested in protecting freedom of expression on social media. And for his speech today, Emmanuel Vargas will share with us his analysis on the right to have a human review a content moderation decision made by an algorithm. So thank you very much, Emmanuel, and the floor is yours. Thank you.
Hi, can everyone hear me? Yes. Okay, thank you. So thanks to everyone for being here. Thanks a lot to Professor Florence Guillaume for inviting me and for organizing this conference and this panel. I'm really happy and glad of being here. And just to say that I'm also really excited of sharing this panel with Pietro and Naomi, who I have read a lot before starting my PhD, and on the first days of my PhD is really exciting, and I can consider myself a fan of what you do. So I hope I'm up to the standards. So yeah, I think that's something that Pietro mentioned in his presentation is important, and is the discussion that has been existing between this dichotomy of human or automated moderation. And before turning to that, I would just like to refer to this quote from the book written by John Milton in the 1600s, which many of you may know, which is called Areopagitica. In this book, or speech that he gave before Congress, he referred to a law that was enacted by those times in the British Parliament to request licensing for every book that was going to be published in the British Empire, right? And something that Milton raised at that point was that in order to have an appropriate review of which book deserves or deserves not to be published, you will need to have the best and most intelligent reviewer of books, right? And this is something that Milton considered very challenging, because if you need the best reviewer in the world, you will probably find a person that is not interested in doing this job. Right? This person will probably want to write other books, read other books, or just read the books that are enlightening for them, and not just to review all the bad pamphlets or all the bad caricatures or all the bad content that he would encounter during this job, right? And this is something that very curiously has evolved and can be very present in the current situation with human moderators in social media platforms, right? You have this discussion of how and who should be in charge of reviewing this content and determining that it's deserved to be online or not, right? And then you have a lot of issues and conundrums around each of these persons, right? Persons saying humans or the algorithms, right? So the algorithms may be really good for doing a quick review, but the humans may be better for giving a context review to the content, right? And in the end, what happens is that we turn into a hybrid system in which human and machines interact And the way in which this interaction happens is what is like the most crucial question at this moment. It's not whether a human or an algorithm should do the work. It's how can they share responsibilities and different faculties to take the decisions, right? And something that is very important to note is that content moderation and this relationship between human and the algorithms is somehow another part of a larger issue related to the automation of industry processes, right? And this automation of industry processes is also an old discussion that has been existing maybe since the 80s or maybe since before. And something that an academic in the 80s, called Bainbridge, raised at that moment was that the better the automation process, the larger and the more complex that it is, the more critical and more crucial and more complex the job for the human is, right? If you have the best automated system, you will still have a need for having a human who supervises that the process is working perfectly, right? That the automated process is not working wrong, right? And you will also need a human that is actually determining how this algorithm or this automated system should work, right? And that makes the issue more crucial. And something that I also see from some of the recent discussions around, for instance, the AI Act and how the human oversight should be involved in different AI-related processes is something that was raised recently by an author called Elena Lenkvist, who said that there should be some questions around not only who is taking the decision, but what is the decision about? What is the human actually looking at? It's not necessarily just the outcome, but also the rules, the processes, and the different frameworks around how to apply these mechanisms, right? There are also questions about when should this oversight be done? Should this be just in the end, or should this be at the beginning, or should this be in different stages of the process, right? And in the end, another question is who should do this oversight? Should this be done just by an engineer? Should this be done by an engineer with some legal background, or should this be done by experts with a high level of understanding of freedom of expression standards? Maybe it should be a combination of that. It's something that is not clear enough, and I think that in a fortunate way is not mandated in a specific way, right? There's no legal provision saying who the human should be, right? And there's also no determination of when and what should be done, right? And that's something that maybe allows companies and allows the discussion to be more rich, because we can actually create different patterns and different ways and different frameworks depending on the type of content and of the type of platform and the different principles that are behind how a platform is built, right? But just to look at how the different types of human oversight can be, we can look at a really interesting taxonomy that was built by the high-level expert group on AI at the European Union, which referred to this need of having a human oversight as a safeguard that is necessary for ensuring that the system is not undermining the autonomy or having other adverse effects, right? So in the end, it's not something that is just a safeguard for itself, but instead a safeguard for allowing human agency and human protections to the outcomes of the process, right? And so these ways of including human oversight are basically three. One is the human in the loop, which is basically including someone who has the capacity of intervening in every decision cycle of the system, right? The other one is the human on the loop, who is a person with the capacity of intervening during the design cycle of the system and monitoring how it operates, right? And finally, we can also talk about the human in command, who is someone with the capacity to oversee the whole activity of the system and with the capacity to decide when and how to use it, and even to decide not to use it, right? And this is something that can be applied in different levels. You may have some systems in which there are human in the loops, on the loop, and in command, or maybe just one of them, right? And now, turning into the legislation, at least at the European level, which is somehow the trailblazer at this moment for these discussions, we can see, of course, that there is a lot of legislation that has been emerging in the last 10 years, if not to say the last 20. Of course, we have this provision in the GDPR related to not having decisions based solely on on automated means. But we can also see that in the DSA, there are some provisions related to how the human should be involved. They may not provide enough clarity at this moment, but I think that they are quite relevant. And of course, they are the legal basis at this moment at the European Union. And well, what we can see is that first, in the DSA, when we talk about moderation on notices done by users, human intervention is not mandatory, right? There is no reference to having a human in the loop at this part of the decision making, but there is an obligation for providing information on this. There is a transparency obligation to say that this moderation was done by an automated means, right? And where we do have a specific mention to a human involvement is in the complaint mechanisms, which are in Article 20 of the DSA. Here in Article 26, we have a reference to having all this process of complaint mechanisms done with the supervision of appropriately qualified staff, right? And this means that there should be some type of oversight. It's not clear where, when, how, and what, right? But it provides this mention for the need of a human oversight. We also have references to the human oversight in the lex specialis of content moderation, which are the anti-terrorism regulation and the copyright directive. There are some mentions there to the human intervention, but as I also mentioned, there is no specific mandate on when, how, and what, right? Just focusing very briefly on the DSA, we can see that these complaint handling mechanisms have some specific mandates on how to act on the complaints that are filed, either against the enforcement of the terms of service or either against the decisions on notice and action, which are just focused on whether the content was illegal or not, right? And what we can see is that there is a request by the legislation to act in a timely, non-discriminatory, diligent, and non-arbitrary manner. And it also establishes that the complaint handling mechanism should determine if there were sufficient grounds or not to have this takedown, to have this decision or not. And depending on whether there are sufficient grounds, there should be an order to reverse the decision, right? And of course, as I mentioned, this should have the supervision of the appropriately qualified staff. And I think that this is quite interesting because it somehow looks like some type of internal judicial review of decisions taken by the system, right? So it not only has to act in this way, non-discriminatory, diligent, and non-arbitrary, but it also should review or oversee whether the decisions to enforce the terms of service complied with the specific mandates that the DSA has about these specific decision-making activities. So it should review if the enforcement of the terms of service was objective and proportionate, and if it took due regard to the rights and legitimate interests of the parties involved. And in the cases of notice and action moderation, it should also look to whether it was timely, diligent, non-arbitrary, and objective, right? So in that sense, it not only provides an obligation on the procedure, on how should it operate, but also it establishes a mandate on what to review, right? If we see all these provisions in combination. And having said that, I would like to turn back to something that was mentioned in the last panel related to sports law and arbitration in sports law. Pietro has mentioned it in an article and mentioned it during his presentation that moderation is not arbitration, but of course there is like a reframing of how freedom of expression disputes are being settled, right? And in the end, we can also see that, of course, moderation is not arbitration because it does not close the door to go to courts. But in real life, we find that most of the decisions will be taken within the internal system of the platforms, within this framework that is built by the platforms. And what we can see in the case law that has been developed in the last 7 years around sports law is a set of standards that maybe in the future, potentially, will develop into something that can be applied into the evaluation of how moderation is performed. And just to mention the case of Mutu and Pechstein versus Switzerland, we can see that the European Court of Human Rights referred to how, in the context of sports, which is international and needs to have expedited decisions, there is some relevance of having a specialized body which is able to rule swiftly and inexpensively, and it's also seen as a figure, as a body that can provide some sort of procedural uniformity and some sort of legal certainty, right? And something that has also been seen in this same case and in other following cases is related to whether arbitration is mandatory or compulsory. And in the specific case of Pechstein, there were circumstances in which this person was actually mandated to go to this arbitration tribunal, the CAS, right? And maybe to some extent we can also discuss whether moderation becomes somehow de facto compulsory arbitration in the sense that no one or very few people will end up going to outside systems, right? Or to the judiciary to solve a dispute. This is something that we still don't know, but maybe seeing how the practice has been, we can also see that most of the disputes will probably just end in the internal part. And something that is also relevant from this case law on sports law is in the case of Al Risa and others versus Turkey, because the European Court of Human Rights did say that the sports litigation contest is not very traditional, right? It's very sui generis. It's very different from what has been traditionally existing. And it said that the fact that this is a sui generis body and a sui generis system doesn't mean that the obligations to provide some procedural safeguards are gone, right? So the fact that this system that we are dealing with today is sui generis may not be necessarily a reason to say that due process is no longer applicable in this context. And the other thing that we have, even if this rough idea that I gave you is not applicable, we can see that these specific obligations on how to decide in the complaint handling systems have very procedural specific obligations that can be taken or translated or fleshed out from the case law related to procedural human rights at the European Court of Human Rights. So we can see that when the DSA refers to timeliness, there is a need to have decisions that don't provide onerous delays on restrictions or long standing decisions without a specific explanation. So delays should be explained. It also calls for diligence. This means that, at least in human rights law, that there should be an ensurement of the procedural rights being enjoyed in an effective manner. And we can also see that when we see that there is a mandate of being non-arbitrary, the European Court of Human Rights has referred to having the decision makers deciding with a delicate analysis of the facts and the law and the different combinations and when the law should or should not apply. And of course, giving convincing reasons of why the decision was reached. And finally, there's also a case law referring to the non-discriminatory element, which refers to those cases in which there is a difference of treatment based on these suspicious categories, the decision should have adequate explanations, right? And this means that all these four mandates and the way in which I see that can be fleshed out is something that I consider raises the standard of the human involvement, right? Something that maybe can be seen from this discussion of the what, the when, and by whom, is that the human involvement should be meaningful and should not just be a rubber stamping of the decision, right? And that's why for instance, what Pietro mentioned of including the human intervention in the design process is very relevant, right? And maybe it also means that the discussion about the different steps and stages in which the human is involved becomes more critical, right? And I would like to connect this, to link this part with another standard raised by the European Court of Human Rights, and is the state's obligation to create or to promote a favorable environment for freedom of expression. This means that the state not only has the obligation to not censor, it also has the obligation to provide the framework for people being able to talk without fear and without undue deprivations of that right? And this is something that means not only providing a framework of rules, but also a framework in which the responsibilities and the different steps and the different faculties of humans and algorithms may be relevant, right? Because it has an effect in how people can actively express themselves or not. So that's something that I consider should be seen, should be a lens for when to discuss this thing. And finally, just to close the presentation, is I would like to refer to a view that was given by Griffin and Stallman recently, and is to have a systemic approach on the human oversight, especially because of this part of the DSA saying that there should be supervision of adequately of appropriate staff, right? This shouldn't be seen as just the rubber stamper, but rather including policy experts who are able to examine the possibility of having systemic flows on the system, a person who is, or persons or group of persons who are able to provide and have bilateral feedback, so people who are able to provide meaningful feedback to the system, but also people who are able to understand what the system is providing to them. And something that is quite interesting is that the level of supervision should be proportionate to the impact of the moderation. So removing someone from the platform, deplatforming, may have a greater impact in freedom of expression, so maybe that implies a higher human intervention and a higher human design, right? Like a more critical design. And finally, of course, there's also a need for knowing that the human intervention should also depend on the context. If there are crises, if there are specific issues that are very critical, maybe the human intervention is more necessary in those specific contexts, so they can actually be meaningful in the decision. So yeah, thank you very much.
So thank you very much, Emmanuel, for this very interesting presentation of the challenges and opportunities of content moderation by automated decisions on social media. So it is with great pleasure that I introduce our next speaker, Naomi Appelman, who is a PhD candidate at the Institute for Information Law of the University of Amsterdam. Her research delves into how technology can obscure, reflect, or amplify social inequalities. She is particularly interested in questioning the contestability of algorithmic systems used for content moderation on social media. And Naomi Appelman also analyzes how European law provides an appropriate legal framework for content moderation systems. Today, she will discuss the obstacles that victims of online harm face in accessing justice and the ways in which social media platforms could improve the situation for victims. So Naomi, you have the floor. Thank you.
Yes, thank you so much for having me, and also from my side, thank you from the organization, Professor Guillaume, thank you so much. So I will switch gears here a bit and speak more about the empirical side of all the legal and procedural technicalities we've been discussing so far. So what I want to do today is take you through a research report I wrote on, based on interviews with 10 European social justice organizations on how they view online harms, what their needs are with regards to access to justice, and crucially, also their perspective on the current regulatory debate and the ability to participate in that debate. So the aim here really is to shed some light on the access to justice needs of different groups, so how, the law we're discussing now relates to what people need. So what I will do concretely is first set up a bit the background of why I chose this particular perspective, then go into the research setup, and then I'll go into 5 key takeaways from the report. And the background I'll keep very brief because I know we're here all with experts on human rights, freedom of expression, and the social media challenges with online harms. So let's start with the background. The starting point for this project is that how online debate is moderated can exacerbate and create harms in and of itself. So here we can think of both vertical harms, so in the relation between platforms and users, as well as horizontal harms, so how users treat each other and how they sometimes treat each other horribly. So if we think about these vertical harms, we can think of unjustified over-removal, unjustified down-ranking and suppression of content. Think, for example, of fat content creators who keep saying that their content is shadow banned, the disproportionate suppression of Palestinian content, or the often removal of accounts of sex workers, for example. Then horizontal harms, we can think of the widespread online harassment of female journalists, online hate speech, and how we keep seeing that these issues are insufficiently taken on by platforms and people have insufficient protection. So this on the one side. On the other side, we know that these harms are just simply not distributed equally. Marginalized groups often experience both these types of harms most often. And there's, combined with this, a wide heterogeneity of the types of harms and impact of the harms. So if we look at this factual basis from an access to justice perspective, we know that social media platforms have been plagued by issues for years in how to address this variety of online harms, right? From people not getting any response from platforms, procedures being opaque or difficult or just not there. And we are well aware, of course, that the DSA tries to expand this access to justice through introducing several platform procedures that have been discussed very clearly and eloquently today already. So this, of course, raises the question to what extent the DSA is able or could be able, with some legal help and policy interpretation, to address this disparate content moderation, this unequal distribution of these different types of harms. So this really is the background against which I set this research project. So what I wanted, because this is the answer to me, the question to me that we need to take on the next couple of years in implementing and enforcing the DSA. So what I wanted to do with this research project is make a small contribution to our understanding of what these harms are to begin with and what people's experiences and needs are with regards to online harms and access to justice. So that for me really is the basis of the contribution I want to make here. So this leads me to the setup of this study. So the central question here I wanted to answer is how European civil society organizations working for the interests and with marginalized or vulnerable groups really see these disparate content moderation practices, right? So the lack of access to justice, these different harms that I tried to lay out, and how they relate to and are involved in the DSA policy debate. And I chose to focus on civil society organizations because they simply are the most likely actors to participate in the policy debate to begin with. And I chose to focus on social justice organizations because they, to me, take in a very special and particular position in these debates, because on the one hand, they do have some experience with these complex European lobbying processes and legislative procedures. But on the other hand, they also have actual experience themselves or representing people with actual experience with these online harms. And they are often not in the center of these digital policy debates, where you have a lot of dedicated digital rights organizations that have fought this good fight for the past 20 years, but are distinct organizations from these social justice organizations. But in the end, this is also what I meant with making a small contribution, as interviewing these organizations and their perspective is just simply not the same as interviewing people about their personal experiences. So I interviewed 10 organizations working on a wide array of topics. Organizations working on sex work, LGBT+ rights, trans rights, women's rights, abortion access, and much more I've outlined here on the slide. The interviews themselves were semi-structured, and I used qualitative thematic analysis in the end to sift through all of them. And in the end, I held a workshop bringing together all the interviewees as well as a wide range of other organizations and academics working on this topic. And to me, the goal really here was to not have yet another very extractive research project where you come into organizations that are already underfunded and overworked and ask them to give you all your data so you can do your fun little research project, and they are left with nothing and basically lost time helping you. So I tried to do that through tailoring this workshop and this report to be also used within their own work and contribute to their own aims. So all of this culminated in this research report titled Disparate Content Moderation, Mapping Social Justice Organizations' Perspectives on Unequal Content Moderation Harms and the EU Platform Policy Debate. So what I want to do now is walk you through the main conclusions and also offer some policy takeaways of what I think we could, or the directions we could go in with these conclusions. But that, of course, is also something I'd be very happy to discuss with all of you in the discussion afterwards. So the first conclusion was just very clearly the heterogeneity of both the impact of these harms as well as the experience, so how often you experience them. So there are several dimensions throughout the interviews that were very clear where you see this heterogeneity. This is in the actions that range really from unjustified removals, the very clear removal or non-removal, but also vague norms, the way platforms are designed, or a lack of protection against harassment. And here, to me, you really see that the way how people view these harms is just much broader and much more diffuse than the terminology and the categories that the DSA and the legal framework offer us. That was very clear to me. Then the impact varies immensely. Context matters, positionality matters, I mean, of course, the individual matters, but some very clear factors that stood out that correlated with how we can understand this impact was, does someone use this platform professionally? Is there some type of economic dependence on these platforms? Think, for example, of journalism, but also certain influencers, activists. Yeah, you get the picture. Are you part of a marginalized group? To what extent are you able to express yourself? Are you able to take up place in public debate outside of these platforms? So how dependent are you for your social, professional, economic connection on these platforms? And finally, also, in what language do you even have your content? Is it even served by these automated content moderation systems we have discussed already in the previous presentation? So these were very clear factors. And then we also had a range of response strategies where I saw a very clear heterogeneity. So the extent to which people were able to circumvent or deal with or adapt based on these harms that we're facing also differed widely, and is something we need to take into account. So what does this mean for the legal framework and for policy, right? So of course the argument here is not that everyone should have a fully specified personalized procedure or remedy to serve every 8 billion people on the planet. However, the DSA is currently very much, in my opinion, on the other side of the spectrum, where you have a fully one-size-fits-all procedural setup that does not really serve any type of differentiation or that does not recognize the different impacts or needs. So I feel that wherever the DSA or the current legal framework, the self-regulatory legal frameworks do allow for that type of sensitivity to context, we should explore and see how we can fill in that space. And specifically that could be the codes of conduct or the risk assessment requirements as just one, I feel, open door in the DSA to enter these type of considerations in. The second conclusion very much builds on this first one, and that is the intersectionality of these harms, if you want to go in and actually understand what these harms are. So this is something that came out so clearly and explicitly in almost every interview, where interviewees explicitly mentioned the harms these systems produce, follow the logic of intersectionality and reproduce oppression that they already face in other parts of society. So we're not talking about a very idiosyncratic or specific type of oppression, but very much a continuity of the issues people already face. That is very, very clear. Crucially, people tied this directly to the platform business model, with the logic that people identify is that marginalized identities are less attractive for advertisement, and as such, the platform visibility structures are really geared towards deprioritizing them. So, the overall conclusion I draw from this theme is that to understand content moderation harms, we need to truly acknowledge the connection to these societal systems of oppression. We cannot view them in some kind of isolation, abstracted away from the actual societies we live in. We need to connect them to the platform business model, and we need to connect them to the social technical systems that are actually operationalizing and shaping the environment people move in. And again, building on the previous conclusion, this translates really to a differentiation of needs and demands. And crucially, if we zoom out from these harms, this also translates to a different access to these policy debates. Because if we can start to actually acknowledge power differentiations in this context, not everyone has the same access to these policy debates. Some problems are taken more seriously than others, and legal and social stigmatization carries over to these policy debates in their lobbying efforts. Think, for example, of sex workers, of abortion activists, of transgender activists. It's simply not the same for other groups. So what this means for a policy agenda, first and foremost, is that we must avoid one-dimensional policies that focus on one type of harm and gear an entire policy process towards that. And I think this is a dynamic we see both unintentionally but also sometimes intentionally, weaponizing a certain harm to perpetuate another type of oppression. Think, for example, of how the legislation to fight human trafficking in practice often functions to make work much more dangerous for sex workers, or efforts to protect the online safety of children can be used to abolish end-to-end encryption. So several EU organizations are already doing amazing work in building these broader coalitions and finding these solidarities, such as EDRI or DFF. And to me, this report shows that this is a very fruitful road to continue. So the third conclusion is that people can be, for very good reason, be mistrustful of formal procedures, and that we need to take into account if we think about access to justice. The interview showed very, very clearly that there's a range of reasons, very rational reasons, that people lose trust in formal procedures and may be unwilling to engage with them. Think, for example, of the criminalization and the structural harm of law in this regard. And the clearest example here is, of course, against sex workers or abortion activists that in a lot of countries are simply exist in tension with the law. And in this sense, history and current politics mean they have very little to expect from formal procedures. And this mistrust also carries over to platform procedures due to them also at the same time experience these systematic vertical harms of removal of content and removal of accounts. So this really zeroes in on issues of data collection, right? What information do you need to provide to access these procedures? Do you need to give your real name, your email address, your phone number, your address, and the connections to law enforcement? To what extent is there a possibility that you complaining about your account can transfer your information somehow to actual policing? So I'll go a bit quickly to this point, but this is a quote that to me very, very clearly outlined this sentiment that an organization representing online sex workers, that they just don't have to believe that these type of governance structures will work for them based on very clear experiences. And to me, this means that we have to think beyond a solely legalistic approach if we focus on these issues of access to justice for online harms. It's simply not enough to think about procedural guarantees and building that and think that we actually solve these problems. This connects immediately to this point, the role of support organizations again, in almost every interview, people brought this up, that it's absolutely crucial in some way or another to have organizations that offer support in the sense of navigating this legal landscape, but also much, much more than that, offering mental help, offering security training, and a much more holistic type of support than only offering a roadmap for navigating the legal landscape. And connectedly, the functioning of these support organizations was time and time again emphasized to be incredibly dependent on the connections they had within the platforms. People said we are able to solve some problems because we have some personal connections within TikTok, within Facebook. We know we have someone's email address. We can find them, and that's how we can solve problems. So if we look at this, the overall conclusions is that we need to look more into how to build these type of organizations that also have some type of independence and are not dependent on informal ties and goodwill from these platforms, that have proper funding and that are grounded in a specific context as to be able to offer people that more holistic support that goes beyond navigating the legal landscape. So to me, this means as a policy point, we need to see how we can actually build this, in what context, where can we ground this, where can we fund this, because it was very clear to me that there's a large need for these type of organizations. The final conclusion is the protection of gray zone content, and this is a bit of a different type of point, but what you see time and time again, because it is the most vulnerable groups that are harmed by these platform harms, that are harmed by other users, and that depend most on the platform for even being able to participate in public debate, there is a need for extra protections because the risk is so high in these type of this type of content. Platforms are also more geared to accept false positives, even though this harms them most. So thinking through in a way of how to ensure that this type of legal and not harmful content that is most at risk can be more protected is, I think, in practice, just something that would help a lot of people. So again, this was just very much a small insight in a very complex problem, and I think there are a range of follow-up questions, specifically with regard to the DSA, but also with regard to how to think of supporting these broader coalitions, how to build this broader way of thinking. So all of all, thank you very much, and I look forward to the discussion.
Well, thank you very much, Naomi, for this very interesting presentation, and need to keep some attention to the harms that content moderation could do to victims in the physical world. I think it's the main point. Okay, so we have few minutes, really a few minutes for one or two questions, if you have questions in the audience or online, because we will have a great discussion after the lunch with all the speakers that are going to be here about procedural guarantees. But if you have one or two questions to Pietro, Naomi, or Emmanuel, we can handle them now. Or maybe some of you want to react with what the others have said. Yes, Anya.
Thank you very much for these fantastic presentations and adding to the different perspectives. So I would like to come back to the due process because it appeared in at least in two presentations explicitly, but also between the lines in yours, Naomi, and the exciting question how to redefine them or to overcome the dichotomy. So basically, if we are facing this mass administration of speech rights, how to define due process, if you could perhaps give me again a definition. You said private, public. So in the horizontal relationship in the US, we know due process in the framework of the 14th Amendment in the vertical relationship. But in the US, we define due process also as meaningful participation and also the neutrality of the intermediary, and it has been mentioned, so my question would be defining the due process, perhaps once again, not just how to reform it, and whether meaningful participation, again coming back to the user, would be part of it, and the neutrality kind of going into trust, and also the legitimacy of the outcome. Is part of it to your understanding, which could perhaps be, in the digital context, very relevant. Thank you.
Thank you so much for the question. It's an excellent question, and I must say, if I had an answer and a definition, I would have solved the problem to a large extent, because that is exactly the intractable problem to a certain extent. Due process means many things. You know, if you look at the European Convention of Human Rights, if you look at human rights law in general, you find a lot of guarantees in there. You find indeed meaningful participation, equality of arms, the right to present your case, but you also find publicity, transparency. You also find independence and impartiality of the adjudicator, right? And all of those guarantees have been developed, and I just mentioned some, I could mention more, of course, but they've been developed with reference to courts. So my open question for you was indeed, if you want to do this transposition, to what extent can you import those ideas? To what extent is it desirable, reasonable, and feasible to do so? And I would say, I think Naomi's research is particularly crucial because it also reminds us that in any event, also we as lawyers are biased. We also see everything as a nail because our hammer is law and procedure, but that does not serve the interests of everybody, and it's not in any event the only way to ensure access to justice. So the problem of the definition is indeed, in a way, the entire problem of what do you want to transpose. Now, if you look at the DSA, it's a very flawed and partial attempt to do that. So if you look at the provisions that Emmanuel was mentioning, for example, you see some aspects of that. Now, some of those guarantees, in a different form, maybe in a reduced form, you find them again in internal complaint handling, in out-of-court dispute settlement, in the obligation to provide reasons, and so on. Why did they go for this procedural approach? Because eventually the substantive underlying problem, the limits of online freedom of expression, is a very difficult problem to solve, even in the EU. You know, approaches to, for example, the treatment of minorities vary widely between different member states. And so the approach was, let's give them a procedure to complain about it. But to what extent the transposition has been sufficient, reasonable, defendable, it's up for all of us to discuss.
So maybe another question? Yes, Sabrina?
Thank you so much for your interventions. I really enjoyed those presentations. I had a question regarding, it's going to be a bit of a different question, around the human elements of content moderation, which Pietro, you spoke to a little bit in your presentation. So firstly, I just wanted to say thank you for acknowledging the fact that there is not only a financial cost to having humans as part of the moderation chain, but also it's a very psychologically and emotionally demanding job for the people who do it. It's outsourced in a lot of countries where they're not making much money, so I appreciate that acknowledgement. The question that I had was, a lot of criticisms that are levied towards platforms are that they are in a financial position to hire more moderators, but they just don't choose to do so because of a lack of political will or whatever the case may be. So my question is, if there were more moderators that were in the loop and they were given more time to assess individual pieces of content, what would the trade-offs there be in terms of actually the speed and accuracy? And is it fair to assume that if there are more moderators, we would get more accurate and precise decisions, or is that kind of an erroneous assumption from the outset?
Yeah, just to say that I had an experience in relation to that involvement of human moderators in specific contexts. I worked at a UNESCO project in Colombia, my country, and one of the activities that we were meant to do was doing trainings to moderators of platforms. And something that was challenging for doing that was that in Colombia, the contact person from Facebook, from Meta, is a commercial point of contact. So this person, he also goes to Congress to avoid repressive legislation, but at the same time, when these type of actions are required, just says that it's not possible because the decision is done in the US. And actually, something that they said was that it was not possible to do any capacity building to human moderators because all of them were in the US, right? And they were probably trained aiming at Mexico and seeing the rest of Latin America as Mexico. And I also see that it will be really challenging to have a specific team in each country of Latin America because they are huge countries. So something that I believe is that it shouldn't be necessarily be something of including more humans for reviewing content and having these armies in every country of the world, but more focusing on what I mentioned in the last point of my presentation, of giving a proportionate amount of people depending on the context and of the type of decisions that are being taken. So the human moderation or human review should be more critical when the impacts are likely to be more critical, right? So if the algorithmic decision making raises the possibility of a decision of demoting someone, maybe the involvement should be more critical there. Or if it's seen that in a specific country there are elections or there has been a recent a democratic crisis, like for instance in Ecuador or in Ethiopia, etc., maybe there should be a trigger for involving more humans in those contexts in order to have someone or a group of people who are able to provide more input, more context to the decision. Because I guess that in the end, something that is relevant is not necessarily just the accuracy, but whether the decision has an adequate reasoning and an adequate evaluation of the issues, and that they are provided in a clear way. And I think that's something that is relevant from the statement of reasons in the DSA. Like, it's not just restricting in an accurate way, like getting the adequate content, but having the proper reasons and the proper knowledge for that.
Do we have a question online? Okay, no question online. So please.
Firstly, thank you all for your contributions. One kind of remark for Pietro in relation to the kind of pizza yeast comment. Like, I understand to one degree it's going to be on like this ODS market to develop on the basis of, you know, a type of harmful content or a platform type. But I was also wondering more like practically moving this to like a workable solution. Who do you think it is on, or like what kind of means do we have as a kind of public awareness campaign so that everyday users are aware? I know that it's written into the DSA that, you know, probably like the idea is that like there's a hyperlink there, but everyone knows that as a user online, you're so less inclined to go down these appeals processes. And I do think there's a lot of, you know, a lot that can be gained from Article 21. So I was just curious as to like moving it to this workable solution in which people are aware whether this is like, you know, some form of advertising, and who you think that may be on. Would it be on an ODS body? Would it be on, you know, the DSE to be working with the Commission in order to spread this as a redress solution, or you know, who should be responsible in some way?
I think that's a crucial question mark for how effective will Article 21 be. And we have learned a little bit from the failure of e-commerce ODR in Europe. One of the reasons why the European public online dispute resolution platform did not work, or at least has not worked so far, but probably it's about to die, is that the average consumer did not know it existed and it wasn't sufficiently informed about it. In my opinion, that does not mean that ODS under the DSA is bound for failure, for sure, because the structure is different. You know, e-commerce is a much more decentralized ecosystem with so many traders, and platforms, very large online platforms, are not so many, and under the DSA, they have more far-reaching obligations to inform the users about the further possibilities of redress. So, for example, giving them a list of all of the certified, competent online dispute settlement bodies. Will that be enough? I would say it's too early to tell, but it's definitely better than what we had in e-commerce. So I'm not ready to give up on that just yet. However, I can tell you, even though these awareness-raising campaigns and transparency measures can be adopted, they're not likely to benefit all stakeholders in the same way, for a couple of reasons. The first one, that, as Naomi mentioned, if somebody structurally does not trust this type of mechanism of redress, they're not going to use it, even if you inform them about it. In fact, they might become more skeptical the more you advertise it. And another thing I am seeing, it's also too early to tell, but I have been in touch with some bodies that are currently seeking certification, and they need to demonstrate expertise. So what are they focusing on? They are focusing on the types of complaints where they think there will be a market and people will pay to get dispute settlement. And the typical example is trademarks. So I'm sure there will be plenty of IP dispute resolution bodies that will try to get certification and will protect trademark holders. For depictions of nudity, the economic incentive behind is much lower. So even if you raise awareness and if you try to boost them, one size does not fit all. We need different hammers in the toolkit, I'm afraid. Do you want to add something?
Yeah, I think this is a crucial question, and it might even be worse than we think, because we did a study in 2020 on the Dutch population where up to 40% indicated they did not even know the simple flagging, notice and action notice and takedown procedures existed. So let alone go to an external dispute resolution body. Just the simple flagging on the platform itself is not that widespread. And to me, one way to address it is, of course, via these campaigns, but another really fruitful way I see is what I mentioned in these support organizations, because there are already a lot of organizations active in their own communities, in their own fields, that can get extra training or funding to also support people with these type of issues. And especially with the type of problems where you don't necessarily have the monetary incentive. So if you're talking about online harassment or online nudity, those type of fields where you don't expect that monetary influx, those type of support organizations or empowering already existing organizations to expand, I think could be a very fruitful way also of helping people that are more skeptical, because an important aspect here is also that these organizations can be mandated to actually follow the procedures on behalf of people. So that is another fruitful avenue.
Thank you. Is there
another question here?
Yes, okay. Yeah. So I think it's going to be the last question.
Hi, thank you for the presentation. My name is Jessica. I work at Aragon. We build blockchain governance infrastructure. My background is actually in tech policy. I worked at Meta for a number of years in a local policy team doing in part content moderation issues. I'm wondering, I have a general high level question on the issue of scale in content moderation. When seeking justice for these kinds of experience, the path towards justice right now is very much like at scale. So you're always escalating up to larger and larger corporations or institutions, larger and more distant from the user experience, especially with the way that these platforms have evolved at the scale that they've evolved at, and like the path basically just gets more and more distant from the community, which it affects. So I'm wondering if you have thoughts on kind of the reversal of that momentum and finding more justice and more localized solutions, and what that can look like.
So who would you like to, yeah?
Yeah, that is an excellent question. It is really a general problem of dispute resolution. You know, the more we make it legitimate and we inject guarantees into it, the more it's going to be geared towards cases where the economic values underlying the dispute are such as to warrant going through all these steps. And if I understand your question correctly, is it, what about the other cases, which is probably the majority of cases, where you don't have really any justification for going through those complex procedures? Now, we already see an attempt in the DSA to mitigate that by saying you don't have to go to court, you can go to these online, out-of-court dispute settlement mechanisms, which are significantly, probably less expensive than a court litigation. But even then, as I mentioned, it's probably not going to be viable for all types of disputes. Now, I don't want to steal the thunder from this afternoon, because we are going to discuss about decentralized solutions, which in a way is a return to the past of content moderation, because in the origin, you know, message boards and so on were actually relying on user peer-to-peer content moderation. But it is a general challenge for all of us to think to what extent you can ensure some kind of redress, also for cases that do not warrant that type of escalation. And I think, in general, it could be decentralized justice or it could be something else, but focusing on the socio-technical system is fundamental. You'll never fix a problem by only hiring more moderators or training them. It's important to look at the technological infrastructure within which justice, between many quotation marks, is being served. And wherever possible, intervening on that. That's what I meant when I said getting your hands dirty as a lawyer.
So thank you very much. Oh, you have, yeah?
Perhaps one crucial way to think about this is not only the case-by-case decision-making, but also how to ensure that the structural issues that are experienced by people actually get fed into some kind of reflective system. And I think that's the aim, of course, of the oversight board, right? That type of functioning. But there, the decision-making itself is very hierarchical and very structured in that sense. So thinking through not only how individual decisions can be grounded in a specific context, but also how the common experience behind those experiences as a structural issue can feed back into actual policy and structural change, to me is a theme that is not often connected to these individual cases.
Okay, thank you so much. Thank you, Pietro, Naomi, Emmanuel, for your kind and very interesting interventions.